Partner and Deputy Head of Arbitration Team at Horizons. On my far left, we've got Paul Suckling, who is also a partner and the head of the arbitration team. And we're joined today by Mr. Guy Elkington. Guy is a chartered quantity surveyor based in the Dubai office of Ankura. He has over 35 years experience in the construction industry, works in projects across Europe and the Middle East, and has been here for 25 years. Yep. Myself and Paul's been here 20 and I've been here 10, practicing mostly construction disputes. Just before we get into the detail, just to let you know, there will be an opportunity to have questions at the end. So if we can leave that until then, that'd be very helpful. So today we're talking about financial pressures and economic impacts on the construction industry. And there'll be a sort of separate but related talk on guerrilla tactics during the project lifecycle. Topics that Mr. Elkington is going to cover today from an expert perspective of the current cause of financial pressures includes things such as deglobalization, the lower margins that are seen in the region, the rise in inflation and their effect on liquidity, the current energy crisis, material shortages, and supply chain capacity. Then we'll segue into Mr. Suckling talking about guerrilla tactics that might occur as a consequence of the financial hardships during the course of the project. And that will be looking at employer payment obligations and failures, performance bond requirements and issues, pressures associated with nominated subcontractors, amendments to contractual terms by employers, and the conundrum of non-payment versus suspension. And then we'll look at options that are available to a contractor because we're going to be looking at it from a contractor perspective. So without further ado, I'll hand over to Mr. Elkington.
Thank you. Good morning, and I hope everyone who's listening online can hear me. Talking about sort of the financial pressures and economic impacts that the construction industry has gone through, is going through, and will be going through over the next sort of 5 to 10 years. And I think we're all sort of aware of the events that have gone on, certainly over the last 4 or 5 years, but the industry at the moment is really in a period of sort of great turmoil. It's facing a lot of challenges, but there's also a lot of opportunity, and many events are sort of coming together, and geopolitical events are coming together that are causing considerable disruption in the supply chain. So we've got sort of things ranging from ships getting stuck in the Suez Canal, we've got conflict in Europe, we've got various trade sanctions around the world, and they're all conspiring to affect the global supply chain in a manner of ways. Now, the Gulf as a region is probably relatively insulated from the soaring costs of energy that we're seeing in certain sectors. But don't forget that most of the things that go into a construction project, particularly plant and process, they're generally manufactured either in Europe or the Far East or in the US, and they're all places where energy costs are going through the roof, and that's all being transfigured down into the capex cost of your project. So we're being affected globally by things going on all over the place. Here in the Middle East, diesel costs have probably doubled, and so the industry is heavily dependent on diesel for its transport, and certainly for contractors for their temporary power. We've got the tail end of COVID, and that's still causing disruption to global supply chains. Hopefully zero COVID is coming to an end in China, but we all know from those of us who've been trying to buy a car in the last 12 months, there's a shortage of microchips, there's shortages of all sorts of things, shortages of shipping containers, shipping costs have gone through the roof, shipping times have gone up. And as a result of all this, the global supply chains that we used to have, which will be concentrated certainly in the Far East, they're now starting to deglobalize. And we are getting people now constructing manufacturing plants in regions closer to their markets. And that's also, the reason why everyone's factories in China was because of cost. But if those factories are now starting to move to other locations, they're more expensive locations. And so costs and goods are going to become more expensive. Now, some of those issues are hopefully short-lived, but others may cause sort of permanent shifts or cause longer-term adjustments. Inflation's probably going to take a few years to bring down, or a year or two. and higher energy prices are beginning, hopefully, maybe going to come down, but they're probably going to remain higher than the levels that we've been used to over the last few years. They're all global issues, and they affect many sectors of many economies. But we also have our sort of own regional issues here. The project market in the UAE particularly has been relatively depressed over the last sort of 3 to 5 years. So tender prices here have remained competitive, but we've been moving into an inflationary market, and contractors have tended to swallow a lot of that inflation, and that's really not sustainable in the long term. US interest rates, as you all know, have been going up to try and curb inflation in the US, and because most of the economies here are linked to the dollar, changes in US interest rates mean changes in local interest rates, and that affects project funding and the cost of capital and the cost of money, which also increases project costs. We're all aware of this, I guess the elephant in the room are the giga projects that are coming online in Saudi Arabia. And they are the scale of what's going to be happening in Saudi Arabia over the next 5 to 10 years or 15 years is unprecedented, even in Middle East standards where we're sort of quite used to enormous projects. We've got potentially trillions of dollars of construction, and these are really only just starting. So even in June 2022, there was $350 billion worth of construction projects in the region were at design stage. They haven't started yet, but they're all about to start. And then we've got, if you look at something like NEOM, the line at NEOM, estimates for the construction costs of the line at NEOM vary between 500 million and $1 billion. Some of you may be aware that Saudi Arabia has won the 2029 Asian Winter Games, and so needs to build an entire winter sports complex in Saudi Arabia. I suspect that's going to be quite challenging in a number of ways, but the estimates of cost of that are $500 billion in that region. And that's just 2 projects out of, tens of projects. And just to put that into sort of context, when we all thought that the construction boom in Qatar for the World Cup was significant, I think the total spend in Qatar for the World Cup, including metro, including all the roads, stadiums, hotels, is around $200 billion. So put it into a scale of $3 to $4 trillion of construction that the regional construction market is going to have to procure and construct over the next sort of 10 years. And we've going to have sort of quite significant capacity issues if we don't do something. And Paul's going to talk about performance bonds in a minute in terms of tactics, but there's been a lot of talks this week in arbitration week about performance bonds. And for those of you who were around in the 2008 financial crash, after the 2008 financial crash, everybody got together and the Basel III regulations were devised, and this is to stress test banks around the world, and they're hugely problematic. They were supposed to come into effect in 2013, and it's been constantly deferred. Well, they're coming into effect on the 1st of January next year. That's 6 weeks away. And there's a possible issue on the horizon with the provision of performance bonds, particularly on-demand performance bonds, and the liquidity issues and the capital issues that banks are going to have to put into place to provide those bonds. And that may also add to an increase in the cost of bonds. And then obviously, as ever in this region, we've always got some geopolitical risk lurking in the background. I think yesterday, a tanker in the Gulf of Oman was hit by a drone attack. That's still being investigated, but it's a volatile region. It's all a bit of a perfect storm, and it's going to be a real problem unless there are some changes in mindset and practice. If you could just change the slide, thank you. That's it, right. So we've got some other issues, and we don't help ourselves with many of these issues. We've got a continuing love affair that we've had for the last 20 or 30 years with fixed price lump sum contracting and contracts which put a very large amount of risk on the contractor. And that's not unique to this region. Other parts of the world have a similar mindset. But the upshot of all that is, and particularly on the back of what's gone on over the last sort of 5-10 years and COVID, we've got a construction industry at the moment that is operating on razor thin margins. And there's very little difference between profit and loss. And oh dear, how embarrassing. Right, sorry, let me just get rid of that. There's not much difference between profit and loss, a bit of a chase to the bottom. And we've also got a fixation in this market where I think there's a frequent confusion that cheapest cost must mean value for money, and it doesn't. And then when we get some problem or some accident or defect or a tragedy, or someone cuts corners to save money, then there's a big uproar. Maybe there's an inquiry, but probably realistically, nothing really changes and we just revert to type. And for those of you that were here in 2006, 2007, there was a construction boom just prior to the financial crisis, and employers were struggling to find contractors. Most contractors had more work than they knew what to do with. And so employers had to start courting contractors, which was an unusual thing they weren't really used to. And we then still had a brief flirtation with contracts that weren't fixed price lump sum. And we had some use of NEC forms of contracting, target cost contracting rather than FIDIC, which was all looking vaguely promising. Procurement styles were starting to move into a direction where there was a fairer allocation of risk. But then along came 2008, all those new forms of contract went in the dustbin, along with any other form of risk sharing, and out came the trusty FIDIC 87 contract amended to fixed price lump sum, and we just reverted back to type with all the risk on the contractor. And that's largely where we've been ever since. The other issues that we've got is obviously time is money, particularly where you've got a rising property market, and we've got a continuing fixation on having construction projects with the shortest possible programs. And that puts pressure on design. Frequently, projects are started before they're even conceptually really thought through. There's big political pressure to start. You've got lots and lots of design changes and lots of issues that have to be resolved post-contract. We've also got the region being known. We've got lots of one-of-a-kind projects or trophy projects or vanity projects, and they're also particularly risky. And they're projects where we're probably building something either at the limits of existing technology, and there are one or two projects in Saudi Arabia where the conception is probably for something where the technology might not yet exist, or if it does exist, it's still very experimental. We also have endemic late payment culture in the industry here, which doesn't help. And for some, all of those risks have just been too much. And a large number of international contractors have left the region and exited this market because it's just too painful over the last 5 to 10 years. And as we know, some contractors have gone bust. So we've got a loss of contracting capacity either through exiting the market or going into insolvency, and a loss of expertise. And we've got a loss of big international commercial entities who've got the financially broad shoulders to take some of the commercial risk that's going to be needed on some of these giga projects. And we need that expertise back. It's not all bad. We've got liquidities back, the oil price is up, cash is flowing back into the region like there's no tomorrow. And we also seem to be in the middle of IPO fever at the moment, where the Gulf is being viewed as an economic bright spot in an otherwise rather gloomy world. IPOs are being oversubscribed, there's more planned. So there does seem to be that there's going to be plenty of capital going into various treasuries and pots around the region, which a very large chunk of that is going to get spent on construction. Now, the difficulty is we're sort of using a procurement model that's been in place for 30 years. And probably, quite frankly, it's probably not fit for purpose for what's got to happen over the next decade. The contracting industry, as I say, hasn't got any fat, doesn't have the fat that it had in it in 2008 when it had got to the end of sort of 4 or 5 bumper years. Then we've had low oil prices, we've had COVID. So there are very few reserves. And I think if we continue as we are, then more people are going to go bust. or you're just going to get contractors who are going to refuse to bid. And I think certainly in the oil and gas industry, I mean, most of my comments are sort of really aimed at the building and civil engineering industry. The oil and gas industry is a bit different. There's lots of different dynamics, and you've got the equality of bargaining power between the parties is very different. But you know, you're going to get contractors who are just going to say, I'm not going to bid, or I'm not going to bid unless you take some of the risk or the pain. You know, particularly specialist suppliers. If you think of a manufacturer of gas turbines or something like that, it's probably only 2 or 3 suppliers in the world, and they can probably say much more and dictate their terms. But if we do continue with contractors on razor-thin margins, perhaps on loss-making contracts or having to absorb large amounts of risk, then what you really end up with is you just end up with contractors trying to recoup any additional cash that they can. And the financial pressures that that places them under really aren't healthy. So you're going to end up with, you know, very claims conscious contractors trying to recoup their loss, going to try and find ways to escape their price that they've quoted and trying to get back to a cost-based thing. And if your design, going back to what I was saying earlier about the rush to start projects before the design's properly developed, if the design isn't developed, you're going to get lots of variations. And a contractor's start position in all those types of scenarios is going to try to say, the change that you've made is of such a magnitude that my rates and prices, my fixed rates and prices that I've quoted to you no longer apply, and I want my actual cost. And that's going to move the risk of inflation away from the contractor and back to the employer. But it's going to do it in a sort of very stressful and argumentative way. We're also going to get many delays where the design's not properly thought through. And I'm certainly aware of arbitrations, particularly post 2008 to 2012, where tribunals did award contractors money for inflation, where that inflation had occurred during a period of delay that was caused by the employer. So again, you're going to get routes away from fixed price lump sum contracts in that way. And obviously, where we've got pressures on costs, there's going to be a temptation to cut corners. Whether it's subcontractors or suppliers, and employers are going to have to very closely supervise their supply chain to make sure that something doesn't go wrong. But probably worse than that, it means the industry's got no money to invest. And it's got no money to invest in developing itself. There's no money to invest in digital transformation, BIM. It's unable to increase its efficiency. And so it's just a self-perpetuating issue with no way to break out. So in terms of sort of solutions or options, I think there's been quite a bit circulating around in the last few weeks on inflation and how to get around it. And there's been a few articles, I mean, defer to these gentlemen here, but a few articles sort of saying, well, can you get around it with force majeure clauses or oppression or hardship clauses under various civil codes? You know, unforeseen exceptional circumstances causing me grave loss, etc., etc. And I think they're generally a pretty high bar to get past, and it's unlikely, I think, to be a route to salvation. We know lots of people did try and run those legal arguments after the 2008 financial crash and from COVID, and I don't think very few succeeded. So I don't think that's a solution. It's not a panacea. But there are possible things that could be done even within the existing sort of procurement philosophy, and that's whether there should be an increase in advance payments with appropriate security. Now, that will allow contractors to purchase materials earlier in the process than they might do otherwise, and able to lock in prices if we've got periods of large inflation. Whether there can be assistance to them facilitating warehousing or laydown areas close to site. I think we've all seen that the whole sort of global supply chain in all sorts of industries has moved over the last 10 years to a sort of just-in-time method, where you get things arriving just in time, but we've seen the events over the last couple of years have really killed that system, and it's not really working. So if you've got your materials secured, they're near to your site or project, you're going to get less problems with shipping, you've locked in your prices, and you've locked in your inflation. And equally, if someone takes their foot off the ball in the Suez Canal, then that can cause problems as well. Should there be an increased use of things like blockchain technology to facilitate quicker payments, better use of materials on site provisions in existing contracts? And I think my other bugbear, as I've already mentioned, is for people to get their design developed and to take the time to get their designs more developed before they start construction. You get lots of change, you get design creep, you get arguments and claims where it's too underdeveloped. And it seems to me also that the other thing that we're not good at in the region, there's very little engagement with the supply chain when you're at the design stage. Most employers just have a design consultant, they get their design to a certain level and go to market. There's no engagement really with the people or the specialists who are going to be building whatever it is that you're doing. And I think there's lots of expertise being lost and knowledge not being used. Now, there's obviously a risk, maybe a commercial risk in that you're losing your power of competition earlier, but should employers really start looking at forms of two-stage tendering? Is it used enough, or is it even used at all in this market? It's widely used in some countries now, and they're getting around many of these issues. We've also got shortages of skilled labor. I mean, labor's traditionally much cheaper in the Middle East, particularly unskilled labor, but are we making enough use of modular design and off-site fabrication, which many countries are very advanced in? Is it explored enough or at all? It depends on where the manufacturing capability is, but I read that there was a Deloitte survey the other day on the US construction industry, and 46% of all the contractors that they'd interviewed said they were going to invest in modular and prefabrication facilities in 2023. But it's a very, very different scenario here. Technology, we're way behind on technology. Data and analytics, the Internet of Things, Europe is miles ahead of the construction industry here. I think there was a report that came out yesterday from a joint report from DLA Piper and a firm called Infralogic called Surviving and Thriving in the Era of Disruption. And 68% of respondents in the construction industry in Europe used artificial intelligence tools in the procurement processes, but only 30% of those in the Middle East did. And only 12% of respondents in the Middle East said they intended to increase their investment in technology, against 47% in Europe. And I know the dynamics here are different and labor costs are different, but when you look certainly in Dubai at the amount of effort that the government here is putting into apps and technology, the construction industry does seem to be way behind. The other area where I think there can be help is specifiers and approvers being a little less conservative. I can remember in sort of 2005, 2006, some of you may, Arab Tech, who were a very large contractor at that time, currently in liquidation, they'd won some very large projects and they couldn't get any steel. And so they went off into Europe and they bought a steel mill and a steel plant to secure their supply of steel. And they then came back to Dubai, happy as Larry, with their steel plant and all their steel secured. And then engineers refused to approve the use of that steel, and they would only approve the use of Turkish steel. And the trouble was that all the Turkish steel plants could only produce 30% of the steel that was needed in Dubai. So engineers were just afraid to stick their necks out and depart from, they didn't want to be the first, they didn't want to be the pioneer, they didn't want to get blamed. So I think approvers should be more adventurous or not, or just look at alternative sources of supply and alternative projects. Bulk purchase, economies of scale, can you get partnerships into your supply chain? I think we're probably going to see increased use of joint ventures where resources can be pooled or shared, particularly if you're having to buy manufacturers or produce your own supply chain, whether it's a joinery factory or making some of your own projects, depends on the circumstances. The other thing is escalation clauses. They're much more in use in oil and gas contracts. I know the dynamics are very different for oil and gas, but they're there. they're in all the standard FIDIC forms. Okay, there are issues in terms of you need to agree what indices you're going to use, but there does seem to be a marked reluctance to even think about that. But they're in wide use in other parts of the world. So the majority of sort of tier one contractors in the UK, they will not sign contracts that don't have escalation clauses in them. And they can do that because they're a tier one contractor. But if you're building some of these large projects, you're going to need tier one contractors, and they're not going to roll over and take that level of risk. So employers and owners now need to think about it. At the end of the day, then, just renegotiating with your supply chain if you can. I mean, that's easier said than done. But I think certainly in 2007, when there were similar inflationary pressures here, some government-related entities did, on the quiet or on an ex gratia basis, did help contractors out, certainly with some of the steel and rebar increases. And if you don't ask, you don't get. So increasing your in-house capabilities, mergers and acquisitions, I think increased consolidation. Do you need to get bigger and merge with someone who's got some of that manufacturing capability, so you're actually in control of your supply chain? Know your supply chain. How often do people, most contracts have a right of audit, and people tend to only exercise that right of audit right at the end when there's a problem or someone comes along with a claim. But those rights of audit often exist all the way through a contract, and really, should employers use those rights of audit to keep an eye on what's going on in the supply chain, and if there's somebody who's looking as if there's a risk of going insolvent or they're struggling, then what measures might be able to take to do that? And there's a big reluctance to use those provisions, and maybe they should be used more widely. I guess ultimately, know your clients and pick your projects carefully. And that's where I am. Over to you, Paul, onto performance bonds.
Good morning, everybody. Thank you very much for coming, and to all our virtual participants. Today, what go. Schoolboy error. There we go. Sorry, got carried away. Lost my train of thought. Where was I? Claims. Hundreds of millions. Liquidate damages. Right, got it. I'm back on track. Okay, yeah. So the employer, of course, he wants to apply liquidated damages because as far as he's concerned, you've delayed the project. If you haven't prepared and submitted a robust extension of time claim with prolongation costs throughout that lifetime of the project, I'm afraid there's only one party that's going to win. And we've got to remember, it is the employer that is holding the money, not the contractor. And as Guy says, this goes all the way down the supply chain. So first of all, the first topic I wanted to talk about are performance bonds. Not necessarily how they're encashed, but actually how they are used and the guerrilla tactics I've seen used by employers and engineers indirectly through the lifetime of a project. Now, even at the very beginning of the project, I've seen pressures placed on a main contractor by an employer in a number of scenarios. One, to accept certain nominated subcontractors to the point where the bond has been threatened to be pulled, even at an early stage, basically a bullying tactic to get them to agree to that particular subcontractor. Subcontractors themselves, and in particular, and nominated subcontractors, due to the financial crisis, have since 2009 incurred significant problems in actually obtaining bonds themselves. Not least, as I'm sure Guy would support, there are certain employers during that period that used performance bonds as a form of alternative credit. Multiple bonds were being called to the point where I can remember one particular project where a nominated subcontractor who is not operating anymore was actually went into print and said, I'm not capable of securing a performance bond due to the fact this particular employer is who they are, because he has that reputation of cashing every single bond. Don't get me wrong, performance bonds are a valuable tool, and that's what they are. But what they shouldn't be is weaponized, really, as a lot of employers and engineers do, to bully a main contractor into simply agreeing to what the employer wants to do. Another prime example is the baseline program. This is what the whole project is based on. If that isn't set in stone, then there are going to be problems. But again, fundamentally, every single project we've ever seen, the employer wants the project built on time, which is understandable, but quicker. And every single time we look at a baseline program, I would ask for forest of hands, but there isn't one. But I personally have not come across any original baseline program that has been approved with the first version. There are multiple versions that are revised. And frankly, they're usually due to the fact that the employer, through its engineer, is trying to accelerate the works. What needs to be done is the contractor, as far as possible, needs to stand firm. If he believes, in particular, say for argument's sake, that a nominated subcontractor is not capable of doing the works, I know, still saying, yeah, he's not capable of carrying out those particular works, then he should stand firm. As Guy's made reference to, FIDIC, still on the same side, don't worry. As Guy's made reference to, we are still using FIDIC forms of contract, and in particular FIDIC 4, which was first produced in 1987 with amendments in 1992. That contract has a specific and express condition whereby if the contractor feels that the subcontractor is not capable of carrying out those works, he can object. Again, unfortunately, it's very, very rare that we see the contractor stand firm on that. And in particular, I can remember one particular instance where even though the main contractor did stand firm on that issue, pressures were put on the contractor to start with in relation to the bond being potentially called. When the contractor stood firm on that point, a commercial agreement was made whereby this particular nominated subcontractor was not capable of providing a performance bond. Therefore, the employer increased the contract price of the main contract. Now, that seemed like a good idea at the time. Yes, everybody was happy. The main contractor had a certain amount of money added to his contract price to accept that risk. I can tell you now that did not work. And that particular subcontractor not only did not perform, it abandoned the works and was actually the fundamental source of delay for the entire project, worth hundreds of millions in dirhams. So this is just from practice, that is an extreme example of why contractors need to be firm and need to be claims conscious. Following on from this quickly, during the course of the project, as I've said, contractors need to be preparing extension of time claims and disruption claims during the lifetime of the project. Again, I think I've seen one project in the 20 years I've been here that actually finished on time. And the reason why that project finished on time was the main contractor accelerated the works, which again cost him a fortune, which he never was entitled to claim back. Be preparing your claims. Don't be forced or pressurized into accelerating your works necessarily if you believe you have a valid extension of time claim. Now, again, unfortunately, that's a balancing act, as I'm sure Guy would agree. If you're left in a situation, which is the norm, I'm afraid, you've submitted an extension of time claim you feel is valid. Unfortunately, the employer, through the engineer, will reject that claim, probably not least for an allegation of concurrent delay. Any of you lucky people who come tomorrow to see the talk will learn all about concurrent delay. I can see a young man out there. You're looking forward to that. It's lovely. But you've got to balance this, you see. You believe you're entitled to an extension of time claim. The employer says, no, there's been concurrent delay or you have caused that delay. If you don't accelerate your works, I will apply liquidated damages. So the contractors are caught in the middle here. There is no easy solution or answer to that question, quite frankly. It's on a case-by-case basis. Sometimes there's a mixture of the two. And then finally, in relation to performance bonds, and again, unfortunately, we have seen this more and more frequently at the moment. Employers use the cashing or potential encashment of a performance bond at the end of a project when the final account is being negotiated, which I think is probably a pretty dirty guerrilla tactic out of all of them, quite frankly. But of course, by that time, the damage has been done. So really, sort of in summation of the performance bonds issue, if any of these factors are being flagged up to you, and especially at the beginning of the project, a contractor should think of two things: whether extremely thinking of pulling out of the project, or at the very least ramping up with his commercial and contracts team to protect himself going down the line further with extension of time claims. So his position should inevitably, at the end of the project, he end up in arbitration. He has the ammunition and defense to run a proper arbitration case. So if we could go on to nominated subcontractors themselves. Yeah. Just briefly, the historical background to why nominated subcontractors came about, and was a very good idea as well, was that employers needed to appoint specialist subcontractors for defined scopes of work. It also was an advantage the employer could directly negotiate with those subcontractors the subcontract price. And that made great sense, in fact. However, what has happened here, especially in the UAE, is that process has been abused. And in fact, subcontractors across the board are actually procured through nomination. And what that means is that the employer negotiates the subcontract price. That subcontractor is then foisted upon the main contractor, but the main contractor enters into the subcontract with the subcontractor. So they're responsible and liable to each other. The employer then simply stands back. Any delay that is caused by that subcontractor is the liability of the main contractor. Now, don't get me wrong, that can absolutely work out. However, in practice, and I think we go on to the next slide, this can and potentially not be the case. At the very least, you end up with this potential triangle of the employer, the main contractor, and the subcontractor. A lot of the time, the subcontractor, the nominated subcontractor, has been working with the employer for years. He's his favored subcontractor. But what happens is that undermines the main contractor's authority. And in particular, when you're coming towards the end of a project where everything is being delayed, especially with the MEP works and the cladding works, those subcontractors are directly and wrongly approaching the employer instead of the contractor, and they're complaining directly about lack of access and so forth. That totally undermines the main contractor's position. What the subcontractor and main contractor should be doing is communicating and working in tandem to actually finish the project. In addition to this, the only but can be very detrimental obligation or power the employer has under the FIDIC set of contracts is that if he believes the nominated subcontractor is not being paid properly or on time, he can pay the nominated subcontractor directly and set that money or contracharge that money to the main contractor, even if it's a case that in fact it's this nominated subcontractor that is a major contributory factor to the delay. And that again can happen. And also, of course, and this is the last slide. What's got to be remembered as well with nominated subcontractors, but especially for argument's sake with the MEP works that are carried out on the project, they can account for up to 30% of the entire project works. So therefore, if their performance is below par, this will actually have a crucial effect on the whole successful completion of the project. So that's why, again, it is very important that if a main contractor believes, certainly if he can have through evidence, move on to the next slide. Yeah, sorry. Yeah, certainly if he can show through past history that he has worked with that particular subcontractor, they haven't performed, this project is say 10 times bigger than the previous project, he needs to stand his ground. Because no matter how bad you think it is, unfortunately in construction, it will always get worse. So yes, so also to be fair, another issue two more points. One is to insist on a performance bond from the nominated subcontractors. If they can't get that performance bond, there's a valid reason for it. And it may not be because of the employer being quite aggressive in triggering bonds. They just may have a very, very bad credit rating. Again, the contract should have a provision that, in fact, if you do not want to enter the contract for that specific reason, the subcontractor will have to look elsewhere and the employer will have to look elsewhere. The contractors need to enforce the contract terms as a whole. So what is crucial is that the contracts or commercial in-house department of contractors and subcontractors need to be aware of these issues. And to be fair, potentially consider appointing lawyers such as ourselves to act in a project counsel role. We're not talking to being on site every single day, but certainly the benefits of having somebody on board, an external advisor, whether it be a lawyer or an expert such as Guy, to come along maybe once a month to review the letters and the issues and actually help the contractor push the job forward, because those issues won't go away. They will fester and they will get worse. Another favorite subject close to my heart, are amendments to the contract. I'm sure if I asked someone to put their hands up, in fact, I will do. Let's have a bit of audience participation. In all of your careers, has anybody come across a situation where as a main contractor or a subcontractor, the original terms of that contract have stayed the same and there have been no amendments to that contract in any way, shape or form? No. Thank God for that. That would have been quite a short slide otherwise. Why do amendments happen to the contract? Well, in my experience, they always almost seem to happen for the benefit of the employer. Classic examples of this, and this can be innocent enough, it can be a value engineering exercise, and that's fine. If, because, for instance, the design hasn't been frozen and the parties come together and they realize that actually there can be a cheaper way of engineering and designing the project, that's lovely. And that's a realistic and sensible amendment to the contract. What normally happens, though, is that, of course, there are significant variations to the project because the design has not been frozen. Therefore, the employer wants the contracts to accept these variations, almost always at a much more commercially acceptable level for the employer. Perhaps the biggest area where amendments to the contract happen is where the contractor is entitled to a significant extension of time, usually halfway through the project or 2/3. The employer doesn't particularly want to give an extension of time, but he knows the contractor is entitled to it. But what he certainly doesn't want to do is also pay any associated costs. So what I've seen happen on a regular basis is that usually a contract has a start date and a completion date. When these amendments to a contract come in, and it can look very attractive on the surface, yes, there'll be a pot of extra additional money, yes, that will be given. It won't be as much as maybe would have been accepted if you'd have gone all the way through arbitration, but instead of having a start date and a completion date, suddenly you have 24 new interim milestones that were never there before. And you have to hit every single milestone for that pot of money to be released. And that is a very difficult thing to do. Unfortunately, or fortunately, contractors and subcontractors are some of the most positive people I've ever met in my life. They think they can always do the job, and that's great. But sometimes it just can't be done. And I can remember, again, being in a situation, it's almost a blueprint of this, where there were 24 additional new milestones. And when the planner was asked how many of these we can hit or actually comply with, it was only the first 8. But the answer was, we're signing it anyway, because there's bound to be more variations. And there were, but there weren't enough to cover all of those new milestones. And then, of course, my particular favorite in these such situations is the clawback clause, whereby right at the end, just as you're about to sign the amendment, at the 11th hour, a brand new clause comes into the contract, whereby if you don't hit all of those 24 interim milestones, all of the money that you've been paid will be paid back to the employer. And yet, unfortunately, contractors still sign those types of clauses. Now, moving on to my last topic, non-payment and suspension. Now, this is probably one of the hardest areas to look at, quite frankly, from a contractor's perspective. There are really two scenarios that can happen. A contractor can slow down the works, or he can accelerate, quite frankly, and or apply the provisions of the contract itself. Now, there's lots of talk of contractors pacing their works. I've very rarely seen that happen actually at the time. It's usually an argument that comes up at the end or after the event. Certainly, if a contractor was to write to the employer or the engineer and request that the works be slowed down or paced, that is never going to be accepted. Unfortunately for the contractor, under the provisions of the normal FIDIC contracts, yes, there is provision for the suspension of the works, but that takes a very, very long time to actually kick in. There could be 3 to 6 months before when the notice is served, before the contractor could even start to slow down or suspend the works. And of course, if he unilaterally suspends or paces the works, he himself is actually causing his own delay. So whilst he may have had a valid extension of time claim up to that particular point in time, he is literally potentially cutting his own throat by slowing down the works. Now, of course, unfortunately, a lot of the time, depending on the type of project, the options are taken out of the main contractor's hands, not least because we come back to our subcontractors, whether they're nominated or domestic subcontractors. Those guys are not working on the same type of budgets. They simply go bust. We haven't got the money to continue. We haven't got the resources. We've had to lay everybody off. So unfortunately, you're caught between a rock and a hard place. My advice, no matter how hard it would be, is to follow the terms of the contract. That's what I would do. That way you are protected at the end of the job. Now, I appreciate that's been a rather quick run through of the situations that you can possibly hit on the site, but I think that really takes us now to closing remarks. I'd just like to sum up from my perspective, make 3 major points from my perspective. I think it's absolutely crucial, whether you are a main contractor or a subcontractor, that you comply with the contract terms, even if the employer or through its engineer, they are not. That's the only safe way you can protect yourself if you are going to inevitably end up in arbitration. Secondly, employ the best team. Now, when I say the best team, I mean internally. I think there's no substitute for a high quality, experienced planner, as they are absolutely crucial to any projects. After all, they are planning the success of the project. In addition to this, the commercial and contractual team of the contractor and subcontractor are absolutely crucial as well. And it is surprising how many times I've seen, in particular planners, very young, very keen, ambitious planners who work for main contractors, they move on. And they move on because they're not motivated to stay, because they can't see a genuine career path. And a lot of the time it's not about money, but it helps. But those are the people that are crucial to you. And again, the commercial people, the quantity surveyors, yes, these are the people that are dealing with the money for you. And then finally, my final point is hope is not a plan. If your project has taken a turn for the worst and continues to do so, don't keep hoping that signing another amendment will work, because it won't. Bring in, not before too long, you do need to bring in experts such as Guy or project council lawyers to prepare your case for the inevitable formal proceedings such as arbitration and potentially the local courts. Thank you very much. That's all for me. But Guy,
And
yes,
I think my closing remark
absolutely.
is,
Sorry, Guy.
Unfortunately, I think procurement strategies don't change unless employers are forced to change. And the only time historically that they've changed is when the commercial realities are such that they can't get what they want unless they make those changes. I think those times are coming and will be coming over the next 5 to 10 years because of what's going on predominantly in Saudi Arabia. And so it's probably better that they start to have those thought processes now and start to try and work through alternative forms of procurement that may need to be tailored to the region, rather than waiting to going out to tender in the time-honoured fashion and then having a year or two's delay because they can't get anybody to tender up or sign up at the price that they want. And it's better to start thinking about that now and not later. That's my closing remark.
Agreed.
Well, thanks very much, gentlemen. I'm sure you'll agree that was very insightful. But if anyone has any questions, now's the opportunity to do so. Don't see any hands going up. No worries at all. Well, thank you very much for coming.
Thank you very much. Thank you. Thank you.